No. I'm not sure it is. Yes. That's right. Do you want me to break that? I took a like sedition. I'm glad. Ron is still there to be there. And really, that's what they've been doing anyway.
Temporarily, he may be on right now, certain. But we can go ahead and do a motion. I think Commissioner Bengal, it's my understanding, is going to be zooming in for two dockets, 047-2025-06 and 048-2025-06, but he is going to be absent for the remainder of those dockets. So how about excusing Commissioner Bengal for all the dockets other than 47 and 48? Is there a motion?
So moved.
Motion from Commissioner Weiser, second by the chair. All in favor, show of hands. Motion passes. Thank you. And then Commissioner Wolford's absence. I need a motion on that matter as well. Commissioner Weiser made the motion. Commissioner Phillips made the second. All in favor, show of hands. All right, that motion passes as well. All right, thank you, gentlemen. First up on the regular docket is docket number 036-2025-06. Peak Environmental Services LLC. Mr. Nathan Morgan is the attorney of record. Subject to this variance of financial assurance. Location is section 30, township 10 north, range 13 west. Counties Van Buren field is B43 well spacing area. Mr. Morgan, why don't you have a seat, sir? Commissioners, are there any recusals on this matter? For the record, there were none. Morgan, would you be so kind as to identify yourself for the record, please?
Nathan Morgan with the Morgan Law Firm, and I represent Texcom Peak Environmental Services LLC. Brian Pogue will be my witness, and is it okay if he comes and sits with me at the table? Okay.
Morgan, I assume you have some exhibits you would like to introduce into the record. Would you be so kind as to list them?
I do have some exhibits. I filed exhibits 1 through 4 with my actual petition. And then also this morning, I have brought exhibits 5 and 6, and I believe that they have been handed to the commissioners. And I can go through the exhibit list.
Well, you don't have to go through them. Yeah, go ahead and list what they are if you'd be so kind. Is this so different? Okay. I don't believe. Yeah. Did you hand them out already?
They're out here.
Okay.
Yes.
There are two, like.
Oh, you put them together.
Yes.
There's 2 sheets. Okay.
All right, Ms. Morgan, if you could, what exhibits do you have?
So we have exhibit 1, which is an aerial map of the Texcom Peak environmental site. Exhibit 2 is the vesting deed to the site that's in fee simple in Texcom. Exhibit 3, 3.1 through 3.13 are actual pictures that depict the site. Exhibit 4 is our notice. Exhibit 5 is our proof of publication, and then Exhibit 6 is an actual survey of the site. And I would ask that those be introduced.
Question is granted, those exhibits 1 through 6 made part of the record. Chief.
So commissioners, is what we're requesting is that for a variance of the financial assurances required from the commission in 2024. In July, I believe the commission was tasked with the DQ tasked the AOGC with amending Rule H1 and B2. When the commission did that and promulgated the rules, they added additional financial assurances for Class 2 commercial wells. Initially, this well has been permitted for 14 years. The financial assurances has been provided in the amount of $50,000. The new rule requests an additional $400,000. And so we are asking the commission for a variance on that we can remain under the $50,000 financial assurance.
All right. You have a witness?
I do. Mr. Brian Pogue.
You swore up front of the time, we're about to give those things and the truth, the whole truth, and nothing but the truth.
Yes, sir.
I received, thank you very much.
Mr. Pogue, can you state your name for the record?
Yeah, Brian Pogue.
And what do you do, Mr. Pogue?
I've been a water disposal business for 49 years.
And you are the president of Texcom Peak Environmental Services LLC.
That's correct, yes.
And where is this well located?
Beach Ranch, Arkansas.
And it is a water disposal well?
That's correct.
Okay, and what type of water do you dispose there?
Basically all oil field fluids.
And generally, the water in that area is what you would consider light water.
It is very light. Yes, 8.4 pounds.
And I'm going to show you Exhibit 1. Exhibit 1, an aerial view of the actual site.
Yes, sir.
Do we have exhibit?
Should have been a part of the original application.
I see it in here. What I have is 3.1 through 313.
So it
That's
should
all
look
I had.
it should look like this. It's on the it should be Exhibit 1 and then the deed. The deed is the next page in the packet.
I got 1 through 13, I mean 3.1 from 313. That's on the first page. Here. Got a page, yeah, page 3.
I have an extra copy if you want me to.
I got it.
Okay.
That's fine.
Go ahead.
I think there was, Morgan.
Okay. So Exhibit 1, Mr. Pogue, is this an accurate depiction of the aerial view of the site?
Yes, I'd say maybe a Google.
Okay, and these are not the exact lines of the site where we obviously are providing a survey in Exhibit 6, but this is an aerial satellite image of the site, correct?
Correct.
Okay, if we move over to Exhibit 2, that is a special warranty deed. And would you agree that this depicts that Texacom actually owns the surface of this site in fee simple?
That's correct.
Okay, and it looks like that this site was purchased in 2014.
Yes.
All right, and then we're going to go to the pictures. So we have pictures labeled 3.1 through 3.13. Can you tell us what Exhibit 3.1 depicts?
Well, let's see, 3.1, I built this site, of course, for water disposal. I'm real big on aesthetics. During the time I built this well, I think the aesthetics was very important to me, so I built this well. This is a pond, aerated pond. So as people come by, whoever, the inspectors or whoever, I wanted the aesthetics to someone who things that this thing looks like a par 3 golf course. We maintain it in a very, very high fashion.
Okay, and the actual pond depicted, that's just for aesthetics. That actually has no wastewater in it, correct?
Oh, absolutely.
Okay. I'm going to show you Exhibit 3.2. Can you tell me what that depicts?
Yes, sir. These are my 2 water tanks. I built this site. I only put up 2 water tanks, and this is my 15th water disposal I built. And these 2 water tanks, I paid $1 million to have these 2 water tanks installed in 2010.
I'm going to show you Exhibit 3.3. Can you tell me what that depicts?
Exhibit 3.3, I'm standing, I built this thing where we have trees, grass. Again, someone come up and looked at this site, church women in a church bus, whoever, they'll pull in right here, and this is what this site looks like every day of the year. And I'm standing on I have a golf tee box where I'm standing. We can golf ball in that pond.
Okay, 3.4. Can you tell us what that depicts?
That is the inside the tank battery. I built this thing with a 7-feet wall around the structure for containment, concrete floor. This picture was taken about a year ago. Concrete floor has never had any water or it's never been washed. It's been there since 2010. It's never been power washed. You can walk on this thing any day in your church shoes, every day of the year.
Okay, so as far as the concrete, you have made the disposal site where all of the water is contained. There's nothing leaking on the open ground. There's concrete over all of the, around all of the tanks.
There's concrete everywhere, yes, fully contained.
Next picture, 3.5.
This would be my, up on top where my injection wellhead is at, the borehole. The long red pump, of course, is an injection pump, horizontal injection pump from Alberta. And then to the left of that is a standby, piston pump. So this is our pumping area and it's fully contained in concrete.
Exhibit 3.6, can you tell the commission what that depicts?
3.6, this is the inside of my water tanks. These are, of course, they're huge water tanks. They're big enough you can play basketball inside these water tanks if you put a goal on the wall. This is the picture showing the floor, the sidewalls, and they have Sherwin-Williams epoxy coatings, such as you would have in Toyota or a big plant would have in their municipal water storage facilities. Same thing.
3.7, can you tell us what that depicts?
3.7 is, this is an offloading pump. If we have compressor water, we offload trucks here with this particular pump. Fully contained. The fluid goes directly to a filter into the tanks, never exposed. And again, we have a 7-foot wall, stone wall filled with rebar and concrete with 19,000 barrels of containment.
All right, the next one is 3.8. That might be flipped around in your packet. Can you tell me what 3.8 depicts?
This is a pond I hammer hoed. Took me probably a month to hammer hoe this particular pond. It's a goldfish pond, and it's about 40 feet from my well. I want everybody to know if they drive up on this site, I have a pond that's clear enough you can walk down and drink water out of it. Lots of goldfish in it. Never have a drop of water on it.
Okay. 3.9, can you tell me what that depicts?
3.9 again is the horizontal injection pump. Big electric drive box. This is at the wellhead situation.
3.10, can you tell me what that depicts?
310 again, this is the part of the tank battery containment wall. You have a little storage filling for parts, filters, whatever that we work inside.
3.11, can you tell me what that depicts?
3.11 would be my office, my driver office building. I'm real big. I've been in the trucking business for 50 years. I'm real big on restrooms. We have full watered restrooms. We don't have porta potties. What comes on my side? We have the best facilities.
3.12, can you tell me what that depicts?
3.12, this will be after a truck offloads his water. This is on the exit drive. I built this situation was kind of off of a little hill. So this is driving up the hill to the exit close to the highway.
And obviously this picture depicts different berms and landscaping. And what is the purpose of that?
Well, again, my partner and I, and Richard and I built this thing. We had spent so much money. At the end of this deal, he says, we're gonna landscape this thing. I said, anyway, we spent $80,000 on landscape on the saltwater disposal. Again, we made it look like a par 3 golf course. We put rock, we slowed the water down, rainwater comes down our site. We collect most all of the rainwater and it goes in our system. We pump it down whole so it doesn't leave our property. But this is the grass, trees, and all of the various things we've done to flow the water down, and for aesthetics.
And so this landscaping actually serves the purpose to catch all the rainwater to make sure that there's no issues or water that leaves the site, that you can pump it all downhill if needed.
That's absolutely right. ADQ loves this deal because we stop the water flow in the sediment.
All right, the last picture, 3.13, can you tell me what that depicts?
Yeah, again, this is at the wellhead situation. We have a big wellhead, two pumps that we can use either one. And this is, fully contained within a fence, lock. Security, so we don't have any entrance or whatever, we don't have people messing with.
Exhibit 5 is the proof of publication, and then Exhibit 6 is a survey of the site. Is this survey an accurate depiction of the site?
Yes, sir. I think that's the actual legal.
Okay.
Legal schematic from inside the survey.
And all of the things that were depicted in this picture, in the pictures, are actually also depicted on the survey, and you can see the layout of the site.
That's correct.
Okay. You're aware that the commission requires financial assurances so they can be assured that they won't be, for lack of a better term, stuck holding the bag if a site goes rogue or goes defunct or anything like that. And obviously you have put up $50,000 as a bond. What is your testimony in regard to why that is adequate financial assurance for the commission?
Well, on this particular site, I never build a water disposal unless I own the property. That's one. So we do own the property in fee simple. We have no royalty and we don't have any issues with landowners. Number two, on this particular well site, when I built this drilled it back in 2010, I drilled this thing looking forward about 15, 20 years. So, people in this state have a hard time getting below 4,000 feet. But anyway, I drilled this well to 6,000. I run 95/8 pipe. I run big pipe down below 1,000 feet below the Fayetteville Shale. And I run inside that 95/8. I run 7-inch pipe down to 6,000. Both of these are cemented to the surface. So right now I have 2 strings of casing cemented to the surface. Inside that, I run 5.5 casing. It's cemented to the surface. So as financial assurance, at some point, I decided to not operate this well. There's no way we could pull pipe. I have 3 strings of casing cemented to the surface. So the best we could do was to put cement plugs in whatever areas that the commission asked us to put in and cut the head off below the surface. There's absolutely no way we could pull actually 4 strings of pipe with the surface pipe because they're all cemented to the surface. So they're locked down. They're locked. We can't get them out. So the financial assurance to plug the well, I mean, it might take $20,000 to actually plug the well above cement. You cannot get the pipe back. So I think that whatever financial assurance we have put up is probably on this particular situation is probably enough. Being that we do own the property, paid $1 million for 2 tanks. I paid $190,000 for the containment wall. I'm not gonna tear down the tanks. I'm not gonna tear down the containment wall. I do have a 4-stage rear pit, concrete rear pit, epoxy coated. I'm not gonna tear. I mean, we can repurpose everything here.
So the purpose is if this was not used for saltwater disposal, you would actually repurpose the facility.
That's correct. We can always repurpose it for something else, but there's so much money in place on hardware and parts. Looking forward 16, 15 years ago that we would never, ever put this site back to dirt. Just not feasible since we own the property.
Okay. And so commission is what we're asking for is a variance that way that we don't have to put up any more financial assurance. The money that we use for the bond, we can continue to operate the facility, the landscape to hopefully shine a positive light on saltwater disposal when people are driving past this well or visiting the site. Obviously, if the variance is granted, the commission would have continuous jurisdiction. I believe in AOGC individual visits the site once a month, we would be committed to, obviously revisiting if for some reason the site is not up to the standards of the AOGC.
All right, thank you, Mr. Morgan. Do you have anything else that you need to add?
No.
Commissioners, any questions? Mr. Chairman?
First of all, I'm going back to your warranty deed. It says special warranty deed. What does that mean? Normally you just get a warranty deed. What's so special about this?
So I believe the special warranty deed was done because it was done from one corporation to another corporation, out of states corporations. And it included all of the equipment on the site, and if you look at the last paragraph on the first page, and it continues into the second page, there was a purchase agreement along with it, and so that is what the special warranty deed is referencing.
Any other questions from the commission?
How much water are you currently disposing?
Not much.
How much were you doing 10 years ago?
Well, I've always limited my water to 5,000 barrel a day max,
That's all you've ever put in there.
5,000 max.
How much are you putting in there today?
We didn't get very much. Right now, since Flyville's taken over, we've not got much water.
Give me a number.
This past month, I don't think we pumped 1,000 barrels. It's gonna change. I have a PO for Flyville now. We will you. Or Razorback.
Any other commissioners?
Staff have anything they want to add?
Thank you, Commissioner Thomas. I did want to add a little bit of background, just so the commission understands how we got to this place from a regulatory perspective. Originally, surface facilities were regulated by DEQ under their Rule 1 or Reg 1, while downhole was regulated by the Oil and Gas Commission. As part of the change to DEQ's Rule 1, the Oil and Gas Commission assumed responsibility for both the surface and the subsurface. And that is what the purpose was for adding additional financial assurances. The downhole plugging is usually the less expensive part of closing up one of these sites when someone goes out of business and is no longer operating the site. I'm happy to have staff pull together exact numbers on those situations where we've encountered that in the past. And this is not a statement on Mr. Pogue's operations or his facility. I mean, it is a very good-looking commercial disposal well. But the assumption of that responsibility by the Oil and Gas Commission was the reason behind the increased financial assurances for these commercial facilities.
All right, thank you, Director Morgan. Anything else that you need to add?
We would just ask for the variance. Obviously, this site is going to be checked, and with the continued jurisdiction, we would be more than happy to revisit. If a variance is granted, we would be more than happy to revisit if for some reason the commission feels that they are not adequately secured. And also it matters because they own the surface, and so it's not a lease issue where the commission is going to have to come back and remediate the surface.
Commissioner Bagel or Commissioner Lawson, did you have any questions?
No, I don't have any questions. Just Randy.
Thank you. Sorry, I cut you off. Was there something that you wanted to add or tell the commission?
Yeah, I just have one thing to say. You talked about the special warranty deed earlier. During that time, Coach Switzer and Toby Keith, they were my partners on this project. And Switzer being Switzer, he has a public company in Houston called Texcom Inc. So he wanted to make sure this was separate from Texcom Inc. This is Texcom Inc. Not his blanket little stock company called Texcom Inc. situated in Houston. That's the underlying reason where it says special warranty deed, so to not cause confusion.
Thank you, sir. Anything else, Mr. Morgan?
I believe there's.
Oh, I'm sorry, Commissioner Thomas, Commissioner Weiser?
Director York, the $400,000 amount, did we set that by our rule? Did the commission do that, or is that number generated by the staff?
Don't have the rule in front of me, and I wasn't part of staff when it occurred, so.
Remind me if I voted for it.
That might take a little bit of research, I'll ask staff, was this, an amount generated by staff?
I think Commissioner Bingle might have some insight on the genesis of that whole thing, but maybe not, I don't know.
Yes, the rule specifies the amount of bond depending on the size and capacity of the individual facilities. The tank storage, whether there's concrete sumps or not, what accoutrements are there. The rule specifies the specific amounts of bond for each one of those accoutrements. And I believe in this case, because of the large tankage and the volume on storage, that provision of 400,000 was derived from that. Gary would have the specifics on what provisions of the rule we use to arrive at that amount.
All right, with that explanation, commissioners, do you need any further explanation? I'm sorry, Commissioner Weiser?
Any history of NOVs for this facility? I know we just took it over, but didn't give.
Not that I'm aware of.
And Brian, what's the cost savings between a $50,000 bond and $400,000 bond?
Currently, my insurance carrier is having a tremendous problem getting a $400,000 bond into not knowing when it's applied to. The cost savings will be thousands of dollars. I don't even know the real amount. I know it's $20,000, $30,000, $40,000 for a bond that,
2 to 3%.
yeah, for the situation. Yes, sir.
All right, any other commissioners?
This Foxborough Peak Disposal Company that sold y'all the land, they're supposed to defend you forever. Are they a solid company, or y'all know anything about them now?
That's part of Barry Switzer and Toby Keefe Steel, but I would, to answer your question, they're very solid, yes, but.
Yeah, well, I'm just reading the language in the document.
Said it's gone from Switzer to Switzer, kind of in the Texcom Peak. And then I actually bought this thing from Switzer's Texcom Peak Environmental. I bought Switzer and those guys out. But Switzer and told me they were Foxborough out of Oklahoma City.
Do we have any other disposal wells that are this size that we charge that much for?
So we do have some other facilities that are in the same category, is my understanding. Overall, of all categories, I think we have a total of 9 that have yet to comply with financial assurance statewide.
They're this size,
I
400.
don't know the exact size of those 9, but they're all commercial facilities.
Yeah, I know we have more commercials. I'm just.
No, I'm sorry, all of those 9 are commercial facilities. I don't know their exact sizes, so.
Any other questions in the commission? Does the commission need any additional information before I shut down the evidentiary record? If not, I will call the evidentiary part of the record to a close.
Let me ask one more question.
Sure, thank you, Mr. Phillips.
And this will be to staff. So y'all said the 400,000, right? So what cost estimate did you use to clean the place up there?
I think the that the most appropriate folks to answer that question would be Commissioner Bangle or Assistant Director Gary Looney. I'm happy to ask them to come to the table if you'd like. Mr. Looney, would you join us at the table? Sorry.
Man of knowledge. Looney, this is eerily reminiscent of my earlier career when I was at the Capitol. And when I was being called up to give testimony before a subcommittee for something I wasn't prepared for. But if you would be so kind as to raise your right hand. Do you swear from the testimony you're about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth? I do. And can you answer Commissioner Phillips' question?
So it's in the commission's rule. That's what the formula is. I think Commissioner Beagle discussed that briefly, that all this is laid out in the rule that was recently passed less than a year ago, maybe now. And staff has changed over with official notices to all the companies that we would be taking over from the DEQ. So all this is done very publicly in public meetings and public settings. We, by the rule, came up each amount for each facility after conducting inspections that we had recently. So this company was like one of 20 plus companies that have commercial class 2 disposal wells and facilities in the state. They all receive letters. So the amount is set by rule. And we just go through adding the amounts by rule based upon the size of the facility.
So what, so I ain't trying to pick about it, I'm just trying to get fully understand. So what number did we use as a clean number? Is it 400? Plug and clean it up, is that?
That's the letter. Again, as Judge Moulton said, I didn't come with a list of notes.
I understand.
But the letter sent to them.
And this may not be a question for you, but just for clarity, so we've always had a $50,000 bond for the well, correct?
Just for the plugging of the well, yes.
What did ADQ have on the site? Or did they require a bond?
I can't really speak to them other than that it's been our history and my personal knowledge that when we run into these situations and we have 2 or 3 current ones in the recent past, the DEQ had zero financial assurance. They may have carried some letter of financial responsibility or equivalent, but at the end of the day, it didn't carry any money behind it. In the facilities, we would plug a well, right, commercial disposal, and the facility would just remain. And they're still out there right now, actually, they're strong. So when the change was made through the public hearing process involved with comment, B2 was amended. That's our financial responsibility rule. That's where all this is plugged in. As Commissioner Bingle laid it out, those amounts were put in the rule, and we just simply do the math. Anything else?
Can I,
Commissioner Phelps, Mr. Looney. So I've got a question. And just since this is a rule, and you're setting these amounts by rule, as a matter of law, does the commission have the authority to grant a variance on this particular rule? It's probably not a question for you, but Mr. Morgan or Mr. Pilkington, is there some authority for the commission to provide a variance that's been set by a rule?
I think in general rule A, there is flexibility.
Okay.
We looked at that. There's nothing saying you can or can't. I think. So the way that it reads, the commission has general authority to do whatever it feels is best interest of the state.
So there's a broad brush ability.
I believe there is. I don't know the exact. We did look at that one.
And I wasn't certain because it been take over from you, whether or not that would still be applicable. I guess it would be.
Background, DEQ did not have financial assurance on these facilities. I remember when we did the transition, that was part of the reason. This, we had a couple bad apples and we needed to clean them up, and we tried to look at the cost for a third party to come in and do the work. So that was part of the transition. DEQ was very happy when that transition is over because they kind of had their hands tied on all.
So no heartburn for legal staff if a variance is granted.
I don't believe so. We looked at this a while back and generally in these type of situations where there's broad authority for the commission to do what's necessary or do what's best.
But I just want to make certain we get that part of the record as well.
Yes.
Thank you, thank you.
We got a 10-minute recess
A 10-minute recess?
for 5 minutes.
A 5-minute recess, whatever recess you need. All right, we'll go ahead and go off the record for 10 minutes and we will reconvene at 10:15. We're off the record. This is.
No, that's not what. Oh.
Nine miles. Yeah, so this is what there's. No, there's.
Oh, okay. I'll probably tell them get that on.
Well, we got several documents. Okay. Yeah, okay. Super, yeah. Okay.
Okay. There is.
Yeah, yeah.
Yeah, it's just.
Yeah.
Well, clearly, so here it is, really most chairman. Okay, there you go. Yeah. What about these are here? I think lost curious. Existing feet. Well, that's. Before the grant.
We would have to say the same if they feel like they need additional.
What's it you call it?
Yeah.
You can't, candidates, I mean, that's more the same.
He went to the bathroom.
All right, we are back on the record. Commissioners, I apologize. I don't remember if I officially shut down the evidentiary part of the record ever or not. But if I haven't, I'm gonna do it again. I'm gonna do it now, and if I've done it before, I'm doing it again. This matter is ready for adjudication. Is there a motion from the commission? Commissioner Wilder?
You know, like I say, person, I don't think we've heard enough information today, for us to make an intelligent decision if we were to change the amount of the bond from what the rule as calculated versus their request for 100,000. I suggest we delay this. Also, in light of there's 20 other companies that some of which have already contacted the commission about believing that the rule is too strenuous on the amount of bond to put up. So this is not the first hearing we're going to have on this subject. So I move that we postpone and look at this again at December hearing.
December hearing, December 2025 hearing. All right, that's Commissioner Wilder's motion. Is there a second?
I'll second it, but I'd like for you to bring some financials on the company.
Well, and we also, the staff should give us their calculation under the rule, how they came up with the amount as well.
All right, motion made by Commissioner Weiser, second by Chair Langley. Director York.
I just want to make a point of clarification or ask for a point of clarification. Just for regulatory purposes, we're not granting the waiver, but we're delaying the date of compliance to December of 2025. Is that correct?
Yeah, that's good. That's the motion.
That's the motion. Second. Motion made by Commissioner Weiser, second by Chair Langley. All in favor, show of hands. Motion passes 7 votes, 8 votes. All right, thank you, gentlemen, very much.
Thank you.
Hopefully you can circle back with staff and
We'll see you guys in December.
yeah, or maybe before that, possibly.
Okay.
You know, there's nothing that would be an impediment for you to file another application in another couple of months, but yeah, by December. All right, thanks.
Thank you.
Do we have a December hearing scheduled this year sometime? The 3rd of December, is that right?
It's usually
I
early.
don't have
in the
a
month.
November, but we have a December.
Let me pull up the actual calendar date.
Just FYI.
Also I didn't vote because I was excused from this docket, so there's not, I didn't know if my vote was recorded or not. I didn't vote.
Thank you, Commissioner Bengal. Note for the record, Commissioner Bengal did recuse from this particular matter.
And I show our December hearing date is December the 9th, 2025 in North Little Rock. It's the scheduled date.
All right, thank you, gentlemen.
Thank you.
Thanks, guys.
Nice one to see.
Thank you, sir.
All right, Mr. Perkins, we're going to skip over the flywheel matters temporarily. And we're going to get to the document 047048. Because Commissioner Bengal is participating in this room. So we have all for a vote. All right, next item on the agenda, document number 047-2025-06. Applicant is Weiser Brown Operating Company. Mr. Daly is the attorney of record. Subject is integration of unleased mineral interest. A location, or multiple locations that's set forth in the application. The county is Ouachita. The field is East Langley. Commissioners, recusals on this matter. I know Commissioner Weiser has recused and Chairman Langley has recused. We still have 6 commissioners, so we still have a quorum. And Mr. Daly, you are recognized, sir.
Thank you, Judge. Can you hear me clearly?
I can hear you.
I do need to recuse.
No problem, Commissioner Thomas. Commissioner Thomas has recused as well. Director, we still have 5 votes, is that correct? Right. I'm sorry, Mr. Daly, yes, I hear you just fine. Please proceed.
Okay, thank you very much. The documentary evidence, all pre-filed, consists of those items listed on Exhibit J, which is the list of exhibits. The expert testimony will be provided by Ken Fritchie as a petroleum geologist whose credentials were first recognized in order reference 68-85. We move the admission of the exhibits into evidence and the recognition and incorporation of Mr. Fritchie's credentials.
Your motion to admit the exhibits is granted, Mr. Daly, and your expert witnesses' credentials are noted and accepted.
Request that Mr. Fritchie be sworn.
And
also, Judge Bolden, I think Rodney may be present in your room, and he'll testify as well, so you might swear them both.
We're going to swear them both in. Gentlemen, do you swear or affirm the testimony you're about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you both.
Let's start with Rodney. Rodney, please state your name.
Rodney May.
And are you employed as a landman with the responsibility of securing leases or participations in connection with, in this case, the Lucretia #1 well in Ouachita County?
Yes, correct.
And have you attempted to secure an oil and gas lease or other agreement from the single individual who has declined to either lease or participate?
Yes, correct.
Were you in effect just told to go away?
Basically, yeah, just basically it wasn't worth their time, basically, so.
All right. Other questions for Mr. May?
Commissioners, any questions? I don't see any. Mr. Daly, your next witness, please.
Ken Fritchie, please state your name and employment.
Ken Fritchie, consulting geologist for Weiser Brown.
Have you prepared exhibits F1 and F2 depicting your opinion as to the geology in connection with the East Langley Field.
Yes.
If you will, discuss first of all, the Lucretia #1 well in reference to the discovery well, the Patrick, and give your opinion as to how good the well is.
Okay, the Lucretia #1 was drilled subsequent to the Patrick 34 #1, which was the discovery well for the Buck Range sand at about 2,050 feet. The Lucretia, the Patrick has been producing since 2023 or first of 24. And the Lucretia #1 has been producing since February of 25. The Patrick, it makes 7 to 8 barrels a day with 14 barrels of water currently. The Lucretia #1 is making right at 14 barrels a day and 8 barrels of water per day currently. These are situated on a northwest southeast trending down to the south fault with a closure up against the fault on the north side.
Since the Lucretia #1 is in production, it is the policy of the commission to apply no risk factor penalty and simply have a back-end option at 100% recovery. Is it likely that that well will eventually even pay out?
Well, it remains to be seen. That it's a low volume producer making water, so it'll be a long payout if it pays out.
In your opinion, is it a better deal for an absent mineral owner to be deemed to have accepted $100 an acre and a 3/16 royalty in this case, rather than wait around for 100% payout and then get charged with the plugging cost?
Yes.
Questions for Mr. Fritchie?
Commissioners, any questions?
Commissioners, I asked those last questions because it is the request of the Weiser Brown that in this case, the default election be the $100 3/16 lease as opposed to the 100% non-consent due to the somewhat marginal nature of the well and the likelihood that if payout were to occur, it would occur in a long time.
All right,
That's
thank
all.
you. Thank you, Mr. Daly. Does that conclude your presentation to your rest?
It does.
Thank you, Tony. With that, I'll go ahead, unless the commission has any questions. Go ahead and call the evidentiary part of the record down. Matters ready for adjudication. Is there a motion from the commission? Move to approve. Commissioner Latta has moved to approve. Is there a second? Commissioner Phillips has seconded. All in favor, show of hands. 5 votes in favor, motion passes. All right, next item, docket number 048-2025-06. Again, the applicant is Weiser Brown Operating Company. Mr. Daly is the attorney of record. Subject matter is integration of unleased mineral interests. Location is part of section 2, township 15 south, range 19 west. County is Ouachita County, field is East Langley. Again, we have recusals from Commissioner Thomas, Commissioner Weiser, and Commissioner Chairman Langley. We do have 5, so we do have a quorum. Mr. Daly, you are recognized.
Thank you, Judge Moulton. The documentary evidence consists of those items listed on Exhibit J. Mr. Ken Fritchie will testify briefly as an expert in petroleum geology. Mr. Fritchie's qualifications were first recognized in order reference number 68-85. We move the admission of these exhibits and the recognition and incorporation of Mr. Fritchie's credentials.
Motion is granted and your expert's credentials are incorporated and recognized into the record.
I also move to incorporate into the record the testimony and given in the previous docket, order reference 2025-06, because as you will see, most of what the witnesses have to say is identical to what they just said.
All right, the decision of the commission in docket 047-2025-06 is incorporated into the record of this docket 048-2025-06. Please proceed, Mr. Daly.
Witnesses again are Rodney May and Ken Fritchie. I request that they be sworn.
Gentlemen, raise your right hands. Do you swear from the testimony about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth? Thank you.
Rodney, please state your name.
Rodney May, contract landman for Weiser Brown operating.
Is this proceeding seeking to integrate the exact same person that was integrated in order reference 047?
Yes, the same person, yes.
And if you were to describe your efforts, are they in fact identical to your testimony in 047?
They are identical, yes.
Any questions for Mr. May?
Questions, commissioners? There are none, Mr. Daly.
All right, Ken, please state your name.
Ken Fritchie, consulting geologist for Weiser Brown.
This is a slightly different situation because we're dealing with an offset well which has not yet been drilled. Is that correct?
Correct.
If you will, describe the geology with reference to the two adjacent wells and give your opinion as to an appropriate risk factor penalty to be applied as to the third well.
Okay, this is a structural trap on the north side of a down to the south fault, trending northwest southeast in the Buck Range sand at about 2,050 feet. The Patrick was a discovery well. With a subsequent well, the Lucretia #1, making 7 barrels of oil per day and 14 barrels of oil per day, respectively. The Lucretia #2 is a step out from the Lucretia #1, and still trying to define the east limits of the field on the Buck Range sand. And the risk penalty factor, I would recommend 400%.
What elements of risk do you consider in making that recommendation?
Well, the sand being present, as well as the structure being high enough to produce, and as well as some fault risk there.
Questions for Mr. Fritchie?
Any questions, commissioners? There are none, Mr. Daly.
That is all we have, Judge Norton.
All right. Thank you, Mr. Daly. With that, I'll shut down the evidentiary part of the record. Matter is ready for adjudication. Is there a motion from the commission? Motion. Commissioner Westphal has made a motion to approve. Is there a second? Commissioner Latter is seconded. All in favor, show of hands. Motion passes 5 votes.
Thank you. Mr. Fritchie is going to leave. I'm going to hang around for the open docket.
All right. Thank you, sir.
Thank you.
Okay, I'll be leaving also myself.
Thank you, Commissioner Bengal, for taking some time out of your free time to give us a forum here this morning. I know we all appreciate it. Thank you.
I wouldn't call it free time, but it was time. So long.
Thank you. All right, next item on the regular docket, number 037-2025-06. The applicant is Flyway Energy Production. Mr. Perkins is the attorney of record. Subject is extension of temporary abandonment status. Location is section 11, township 10 north, range 15 west. Counties Van Bureau, field B42 bus station area. Any recusals on this matter, commissioners? No, for the record, there was none. Mr. Perkins, you are recognized.
Thank you, Judge Moulton. The pre-filed exhibits are listed on page 2 of the application. Those include a list of the parties receiving notice. B is a fluid level test of June 13, 2024. C is a proof of publication. D is an affidavit of notice. The originals of C and D have been provided to Mr. Phillips this morning. I would ask that those exhibits be admitted.
Motion is granted. Those exhibits are part of the record.
This is a typical application for extension of temporary abandonment status. This particular well, the Clark 1015-3-11-2 H2, requires the removal of some stuck equipment, replacing tubing, plunger installation in order to be returned to service. The applicant anticipates it can be returned to service economically. The estimated break-even price is $3.41 an MCF. As always, Flywheel would agree to the commission imposed restrictions on a temporary abandonment restriction. That's all I have.
Thank you, Mr. Perkins. Any questions? Does that conclude your presentation, Mr. Perkins?
Yes, it does.
Call the evidentiary part of the record closed. Matter ready for adjudication. Is there a motion from the commission? Move. Commissioner Phillips has made a motion to approve. Is there a second? Commissioner Weiser has seconded. All in favor, show of hands. Motion passes 7 votes. Next item on regular docket 038-2025-06. Applicant is Flywheel Energy Production LLC. Mr. Perkins is the attorney of record. Subject is extension of temporary abandonment status. Location is section 2, township 7 north, range 15 west. County is Conway, field is B43, well spacing area. Any recusals on this docket? No, for the record, there were none. Mr. Perkins, you are recognized.
Thank you, Judge Moulton. The pre-filed exhibits are listed on page 2 of the application. Those include Exhibit A, list of parties receiving notice. B is the fluid level test of June 12, 2024. C is a proof of publication. D is the affidavit of notice to interested parties. The originals of C and D have been provided this morning to Mr. Pilkington. We would move for the admission of those exhibits.
Motion is granted. Those exhibits are made part of the record.
This particular well, the Mary McLaren or McLaren Mary 715-3-2H26 is one of 6 high water rate wells on this pad. Over the last 4 or 5 months, you've had at least 2 others in this 6 well group come before you for a similar application. I mention that because all of these McLaren Mary wells will have to be part of a group that they return to service at the same time because of how they will have to manage the water production. The workover here likely would require the applicant to round trip all the tubing string and install gas lift strings and would need to be coordinated, as I mentioned, with all the other wells involved on the pad. With that said, Flywheel believes that the ultimate production from these wells is sufficient to warrant their economic return to production. If you looked at this well individually, assuming the water production was coordinated with the other wells, the break-even price is estimated to be $3.71 today. The Flywheel would, of course, agree to all the commission-imposed restrictions on TA extension wells. With that, I submit to the commission.
Thank you, Mr. Perkins. Any questions? Include your presentation?
It does. Thank you.
Thank you, sir. Evidentiary record is closed. Matter is ready for adjudication. Is there a motion from the commission? Commissioner Westfall has moved to approve. Is there a second? Second from Chairman Langley. All in favor, show of hands. Motion passes 7 votes. Next item, docket number 039, 2025-06. Applicant is Flyway Energy Production LLC. Mr. Perkins is the attorney of record. Subject is extension of temporary abandonment status. Location section 14, township 8 north, range 14 west, counties 500. Field is B4, flood spacing area. Refusals on this matter, commissioners. The record, there were none. Mr. Perkins, you are recognized, sir.
Thank you, Judge Moulton. The pre-called exhibits are listed on page 2 of the application. Those include Exhibit A, list of parties receiving notice. B is the proof of publication. C is the affidavit of notice. The originals of B and C have been provided this morning to Mr. Pilkington. I would ask that those exhibits be admitted.
Since granted, those exhibits are part of the record.
This one is a little bit different. This particular well, the Scroggins 814-4-14, is a saltwater disposal well. There's nothing wrong with the well. It's just not logistically in the right place at this moment. But Flywheel wants to retain it, either to replace the disposal capacity when another well goes down, or to handle new disposal needs, as Flywheel has once again begun to drill wells. They're drilling a well right now, unless they completed it in the last day or two, in Cleveland County. And not the same as here, but they're going to drill at least 3 to 5 wells this year. And if those prove positive, intend to embark on a larger drilling program. And so they want to retain this saltwater disposal well for future use, and would ask that it be allowed to do so. As always, Flywheel would agree to the commission imposed restrictions listed in the application. That's all I have.
Thank you, Mr. Perkins. Questions? Anything else?
Nothing further.
Call the evidentiary part of the record to a close. Matters ready for adjudication. Is there a motion from the commission? Chairman Langley has moved to approve the application. Is there a second? Commissioner Weiser has seconded. All in favor, show of hands. Motion passes 5-7 votes. Next item, docket number 040-2025-06. Applicant is Flyway Energy Production LLC. Mr. Perkins is the attorney of record. Subject is extension of temporary abandonment status. Location is section 4, township 9 north, range 12 west, counties Van Buren, field 43 west spacing area. Recusals, commissioners? So for the record, there were none. Mr. Perkins, you are recognized.
Thank you, Judge Moulton. The pre-filed exhibits are listed on page 2 of the application. Those include Exhibit A, list of parties receiving notice. B is the fluid level test of June 20, 2024. C is a proof of publication. D is the affidavit of notice to interested parties. Originals of C and D have been provided this morning to Mr. Pilkington. We move for the admission of those exhibits.
Motion is granted. Those exhibits are part of the record.
This particular well, the Snead 9-12-1-4H, is a horizontal well in Van Buren County. The applicant needs to perform some wireline work to ensure the existing tubing is unobstructed and has integrity. It will need to install a plunger lift system and unload the well by swabbing and/or gas lift. The applicant believes, however, that it can be returned to service economically, and estimates the current break-even price based on the information available to be about $2.55 an MCF. As always, Flywheel Energy would agree to the commission-imposed restrictions on extended temporarily abandoned well.
Thank you, Mr. Perkins. Questions? Including presentation.
That concludes my presentation. Thank you,
Thank
Judge.
you, sir. Close the evidentiary part of the record down. Matters ready for adjudication. Is there a motion from the commission? Commissioner Phillips has moved to approve. Is there a second? Second. Second from Chairman Langley. All in favor, show of hands. Motion passes 7 votes. Next item, docket 041-2025-06. Applicant is Flyway Energy Production LLC. Mr. Perkins is the attorney of record. Subject to extension of temporary abandonment status. Location is section 6, township 9 north, range 13 west, counties Van Buren. Field is B43 well spacing area. Recusals on this one. No, for the record, there were none. Mr. Perkins, you are recognized.
Thank you, Judge Moulton. The pre-filed exhibits are shown on page 2 of the application. Those include Exhibit A, list of parties receiving notice. B is a fluid level test of August 28, 2024. C is the proof of publication. D is an affidavit of notice. The originals of C and D have been provided this morning to Mr. Pilkington. We move for the introduction and admission of those exhibits.
Motion is granted. Those exhibits are part of the record.
This particular well, the Wood Charles 913-1-6H, requires, in order to return it to service, the reinstallation of permanent gas lift compression and a plunger installation. The applicant believes it can be returned to production economically. The currently estimated break-even price is $2.83 an MCF, and Flywheel would agree to the typical commission-imposed restrictions.
Thank you, Mr. Perkins. Questions, commissioners? Conclude your presentation, Mr. Perkins.
It does. Thank you, Judge.
Call the evidentiary part of the record to a close. Matter ready for adjudication. Is there a motion from the commission? Commission. Now you're. Commissioner Westfall moved to approve the application. Thanks for a second. Commissioner Leonard is seconded. All in favor, show of hands. Motion passes 7 votes. Next item on the agenda, 042-2025-06. Applicant is Van Buren Energy Production LLC. Mr. Perkins is the attorney of record. Subject to extension of temporary abandonment status, location section 15, township 10 north, range 14 west, counties Van Buren, field is B43 well spacing area. Recusals on this matter, commissioners? So for the record, there were none. Mr. Perkins, you are recognized.
Thank you, Judge. The pre-filed exhibits are listed on page 2 of the application. Those include Exhibit A, a list of parties receiving notice. B is the fluid level test of June 13, 2024. C is a proof of publication. D is the affidavit of notice. The originals of C and D have been provided this morning to Mr. Pilkington. We move for the admission of those exhibits.
Motion is granted. Those exhibits are part of the record.
This particular well, the Henderson 1014-1-15H, the applicant would like to retain this well in order to return it to production. There's a little bit of unknown about it. The applicant will need to perform wireline work to ensure that the existing tubing is unobstructed and has integrity. It will need to install a plunger lift system and evaluate the need for compression. The worst case break-even price, assuming all of those things are bad, is $4.51, a little higher than otherwise, but the point is they're not sure that all of those things will be needed. They want the opportunity to evaluate the well properly and make a decision at the time. So they would like to retain this well with the hopes of returning it to economic production. And of course, Van Buren Energy would agree to the typical commission imposed restrictions.
Thank you, Mr. Perkins. Questions? Conclude presentation, Mr. Perkins.
That concludes my presentation.
Call the evidentiary record to a close. Matters ready for adjudication. Motion from the commission. Commissioner Weiser has moved to approve.
Second.
Langley has seconded. All in favor, show of hands. Motion passes 7 votes. Last item on the regular docket this morning, docket number 043-2025-06. Applicant is Razorback Production LLC. Mr. Parkins is the attorney of record. Subject is extension of temporary abandonment status. Location is Section 5, Township 11 North, Range 9 West. County is Cleveland County. Field is B43 well spacing area. Any recusals on this matter? Correctly, there were none. Mr. Perkins, you are recognized, sir.
Thank you, Judge. The pre-filed exhibits are listed on page 2 of the application. Those include Exhibit A, a list of parties receiving notice. B is the fluid level test of July 19, 2024. C is the proof of publication. D is the affidavit of notice to interested parties. The originals of C and D have been provided this morning to Mr. Bookington. I would ask for the admission of those exhibits.
Motion is granted. Those exhibits are part of the record.
One real ticky correction that I have on myself, in the first line of the actual letter, it says Razorback Energy Production LLC. That's not correct. The correct name is Razorback Production, and everywhere else it says that, but I made a mistake. So I would ask for that correction to be made.
That correction is noted. Your motion to correct it is granted. And the record will reflect the accurate name of your client.
Thank you, Judge. This EZEL 1191-5H is going to require a wireline job to restart the plunger operations and some additional minor workover items. The applicant anticipates this well can be returned to production economically and predicts at this point the break-even price of $1.71 an MCF. So it's already there. I'll just remind the commissioners, Razorback Production is the company that has relatively recently acquired the assets of Merit or MMGJ. And so they're just now evaluating these wells that Merit had for returning some of the TA wells back to production.
All right, thank you, Mr. Perkins. Questions from the commission? Conclude the presentation, Mr. Perkins?
It does.
Thank you, sir. Call the evidentiary part of the record to a close. This is ready for adjudication. Is there a motion from the commission? Commissioner Phillips, approve the application. Is there a second? Commissioner Lawson has seconded. Thank you, Commissioner Lawson. I don't mean to overlook you. You're just a small visage up on the screen.
I'll try to get bigger.
All for a show of hands. Motion passes 7 votes. Thank you, Mr. Parker.
Thank you, Judge.
Commissioners, we can move into the staff docket, or if you need to take a 10-minute break, it's about 10:30. What's the pleasure of the commission? Would you like to press forward or take a break? Director, I don't know what time their lunch is supposed to be here. But if we finish up, let you know. 11:30. Staff, whatever the commission wants, we can move forward. It's about 10:30 right now, commissioners. I figure. How long do you think staff's presentations are going to take?
My first one will be the quickest one you've ever seen. Third one may take a little bit of testimony, and the training could say.
So 30 minutes in total?
I would think that's the safest.
We do have an open document matter that might have some discussion.
So, okay, all right,
We use it.
all right. Commissioners, what's the pleasure? You want to press forward? Or you want to take a break? What would you like to do? You both? Thank you, Mr. Chairman.
Thank you.
We are on the staff docket on the agenda. First item up is docket number 033A 2025-05. The applicant is commission staff and is the attorney of record. The subject is request for order to compel compliance and assessment of civil penalty. Location is section 7, township 7 north, range 18 west, county field is Oak Grove. On this matter, commissioners? For the record, there are none. Upton, you are recognized, sir.
Thank you, Judge Bolden. After discussion with commission staff on this matter, commission staff would move to dismiss this application.
Motion is granted. This application is admitted.
Ms. Rainey's going to do the next one.
And what is getting passed out is an updated version of the application. Right, thank you, Judge Moulton. There are 3 pre-filed exhibits. Exhibit A is the Texas company contact information retrieved from the AOGC website. Exhibit B is the commission log of well form, and Exhibit C is the notice of hearing. Commission staff moves for introduction of these exhibits.
Motion is granted. Those exhibits will be part of the record.
Thank you. The commission approved an emergency application in docket number 034A-2025-05, which allowed commission staff to expend funds from the abandoned orphaned well plugging fund to replug the leaking well. Staff requests a commission order authorizing it to expend funds from the Arkansas Abandoned and Orphaned Well Plugging Fund to complete site remediation.
Just to give a little additional information, this is the well that we brought as part of an emergency last month. The well is plugged, the site is secure. No additional leaking from the well has been observed, so we had a successful plug job. That being said, given the wet conditions over the last few weeks, we haven't been able to complete abatement activities at the location. So what we're asking for is, because the emergency order only gave us that authorization, that emergency authorization for 30 days. We're beyond that time, or soon to be beyond that time, and we're still going to have some expenditures as far as surface abatement. Just that's the purpose for this application, is finish the job since the emergency order time has run.
All right, thank you, Director. Commissioners, any questions for Director York or Ms. Rainey?
Does that include some minor road work?
It should. It should.
Any other questions? Rainey, does that conclude your presentation?
Yes, Judge Moulton.
Call the evidentiary part of the record to a close. Matters ready for adjudication. Is there a motion from the commission on this matter?
So moved.
I'm not certain who voted. Oh, thank you, Commissioner Lawson. Commissioner Lawson has moved to approve. Is there a second? Chair Langley has seconded. All in favor, show of hands. Motion passes 7 votes. Next item on staff's docket 034A that's 2025-06. Applicant is commission staff. The attorney of record is Ms. Rainey. The subject is request for expenditure of funds from the Abandoned and Orphaned Well Plugging Fund. Location is section 34, township 15 south, range 15 west. County is Ouachita. Field is Smackover. Any refusals on this matter?
You get down wrong docket.
Oh,
Wrong. We just don't do that.
oh, what did we do then?
Wrong.
Oh, we're on 49. We did this one?
Yes, sir.
Oh,
We dismissed the first.
oh, we did?
Mhm.
All right. Apologies to the commission. Let's try this again. Last item on staff docket is 049A 2025-06. The applicant is commission staff. Mr. Cookington is the attorney of record. Subject is request for well abandonment. Location is section 5, Township 16, South Range 19 West. Counties Columbia, field is Stevens. Recusals on this matter, commissioners. No, for the record, there were none. Hutchinson, you are recognized, sir.
Thank you, Judge Moulton. First thing I would move for is introduction of exhibits into the record. They would include Exhibit A, the Mission Form 1 from operator. Exhibit B is the affidavit of notice of hearing. Exhibit C is the copy of notice of hearing. Exhibit D is the proof of public notice from the Arkansas Democrat Gazette. We would move for introduction of each of these exhibits into the record.
That motion is granted. Those exhibits are made part of the record.
Thank you, Judge Moulton. At this time, I would take testimony from Mr. Looney.
Looney, if you could, do you swear affirm the testimony about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Thank you, Judge Moulton. Mr. Looney, you are employed by the Arkansas Oil and Gas Commission, correct?
Correct.
I always love asking a question. You're aware that an application and a request for well abandonment was filed in docket number 049A-2025-06, correct?
Yes, sir.
Why did commission staff file this application with the commission?
Commission staff has been made aware of a very old legacy tank battery that is adjacent to this well site. This is in our area of current plugging operations in our Department of Interior federal funded grant. That we're plugging out several wells and removing tank batteries and doing surface abatement in the Stevens field area. This is to the south of Stevens, the town, but still within our area of operations that we are currently working in. That tank battery, we don't know how long it's been there exactly. We don't have any records. We can't identify it by tank numbers, but it is basically 100 feet from this former well pad. And so process of moving anything through the abandonment to the plugging fund is this method. So while we list a well, we don't disagree that the well is plugged, but there is a remaining tank battery there that needs to be filled.
Can you give a brief summary of the current liability of the operator?
LNP Oil Company does not operate wells in the state anymore. They had never paid any annual well fees or into the program like that. I don't have a date they last operated any wells, but I know they plugged this well in 2013. They began as operator of this well in 1983. This well was originally drilled in 1962. Staff surmises that the tank battery that's out there, that is a couple of tanks you can see through basically, was an original tank battery, and their newer battery, the one that they may have replaced or, excuse me, removed, was a replacement of the original tank battery for the well. Staff looked in that 40 and the adjacent 40 and found no other wells that were ever drilled. So we can only assume that you got to have a well before you have a tank battery. So there had to be this well that was related to the tank battery that still remains out there. In fact, this is the number 2 well. This is the one the tank battery is close to, but they actually operated number 1 and number 2. And number 3 was drilled, but it was unsuccessful. That was, again, back in 1962. They are a subsequent operator. LNP, while they are not an operator anymore, the people behind it, some of them is Bobby and Janice Long. Some of you may know them. They are a local resident of El Dorado and proprietor owner of Jan's Realty. The address for, last known address for LNP and Form 1 is the same as the real estate company here in El Dorado. And so they did receive the notice and did reach out to us to say, hey, we plugged the well and, you know, took care of it. And again, we don't deny that they plugged the well, but there is a remaining tank battery out there that we cannot, I guess you could call it, assign to any other operator. And it's just, again, a process of moving through to the orphan well plugging fund so that we may clean this up, since the company itself is not around any longer.
No further questions.
Commissioners, any questions? Conclude your presentation.
That concludes, yes.
I didn't shut down the evidentiary part of the record. Matters ready for adjudication. Is there a motion from the commission? Approved. Commissioner Liner has moved to approve. Is there a second? Second. Commissioner Thomas has seconded. Wait a minute. No? Yeah. Work maybe. All in favor, show of hands. Motion passes 7 votes.
Thank you.
Open docket. Commission will now hear public comments concerning the following areas of commission jurisdiction. Whether or not waste of oil and or gas is taking place or is reasonably limited. The optimum equitable rate of production for each controlled source of supply. Whether or not any rules and regulations currently in effect should be considered for revision. Or if other additional rules should be considered. Other matters brought before the commission over which it has jurisdiction. The record, there was no response. Director, you are recognized and you've moved down.
I have to participate in the open docket portion.
Okay.
If the commission will recall, and before I get started, you should have 2 items that I passed out before the hearing began, which is a copy of what I'm referring to as the draft model brine unit operating agreement. And also with that is a draft model brine lease to function with that unit operating agreement. If you'll recall back in the April hearing when the unit applications for these brine units came before the commission, Commissioner Walford, as part of his motion, requested that commission staff work to come up with a model unit operating agreement. And as part of that, I requested at that time all of the council who were representing the various interests that had applications before the commission, also council that was representing South Arkansas Mineral Association. And in addition to that, we later expanded the group to direct industry participation from both Albemarle, Lanxess, South Arkansas Minerals requested to participate, or excuse me, South Arkansas Lithium requested to participate. I'm happy to say the group had some productive meetings working through the unit operator agreement that was provided at that time by Saltworks. We went through and you can see from the edits, everything should be highlighted in that large document. I don't want to go through it line by line because it is pretty expansive. But commission staff has kind of arrived at this place where we believe that this is a fair and equitable and functional unit operating agreement for to be used as a model for those hearings that were heard in April and any future brine unit, similarly situated brine units that come before the commission. I know that this commission enjoyed probably a whole lot of efficiencies gained by having model forms when the Fayetteville Shell took off. And I think and I don't want to speak for Commissioner Walford, but I believe his thinking was that if we had model forms, we could be similarly efficient again. So I present both that model unit operating agreement and also, and this one is a little bit smaller, but the model form lease for your review. And I'm happy to answer questions. I believe that there are, I think Mr. Daly stayed on the line to participate here. And I believe Mr. Rankin, possibly Mr. Perkins may have comment. Oh, absolutely. Yeah, I've got extras up there too. Sorry.
All right, commissioners, any questions for the director? Or I guess perhaps Mr. Rankin or Mr. Daly is right.
I'll go first. I'll go first if you want me to, Judge Moulton. And tell you that on behalf of Saltworks, we have no problem whatsoever with staff's draft. I think we would have problems with any other proposed additions or changes to staff's draft, but we fully support staff's draft of the unit operating agreement. With respect to the lease, I think Director York and I have had conversations and he's clarified staff's position, but I want to get it on the record that this is not a lease that industry would be required to use in private transactions, nor is it a lease that industry would be required to use by a willing lessor who was integrated and leased during the election period. Rather, this lease is the default, which would be imposed upon a party who fails to elect affirmatively anything. And with that limitation, we support it as well.
Thank you, Mr. Daly. Mr. Rankin, do you want to chime in on any of this?
I do, thank you. I'm Jim Rankin. I'm representing Occidental Petroleum. If you'll recall, Occidental was integrated in docket number 024, 2025-04 into this unit. It's very possible that Oxy would be a participating party. They could make an election during the time to do that, and I appreciate the staff's efforts in putting forth the editing and the additions and subtractions to the draft agreement. And I think Oxy would agree that most of the changes suggested by Saltworks are good, and they update the agreement to what's going on now in the industry and how it would apply to the lithium extraction from that. But having said that, when we looked at the comparisons between what was submitted by Tetra, Standard Lithium, as compared to the existing joint operating agreements by Lanxess, a lot of that language was in there and approved by other operators, and Oxy felt that some of that language was better suited to address the situations here. And with that, there are still a couple of provisions that are in the staff recommended draft that Oxy would at least like to point out its objections to and have the commission consider making a couple of further changes on that. The first one is in section Article 5B. I believe that's on page 14 of the draft. There's a section there that's styled deemed approved or prior actions. And we initially had an objection to that because as a reasonable and prudent operator standard is implicit in any joint operating agreement, that's going to apply to the agreement to any operator. And as someone that has been integrated and could come in as a participating party, this section basically makes it so that a party that participates and signs on to the agreement would be bound by some action of the operator of which it had no knowledge and couldn't have had knowledge. There could have been actions taken by the operator that never made it into the public domain and were never provided to a participating party that was presented this document having to make that election. Having said that, I had provided Director York some changes to that language by email on Friday, June 20th. And I'm not sure how to present that other than to read it at the moment, and the director can forward that. Was the email forwarded?
I believe that it was not.
Okay. So what I had proposed to do is in that particular section is to limit somewhat what actions the operator can take prior to a party becoming a party to the agreement to actions of which that party was aware. So after the contract area, we're proposing to add the language, and I'll just read it all together so that there's no misunderstanding about where we're putting it. all lawful actions taken by the operator prior to the effective date in furtherance of all operations on the contract area, comma, which as of the effective date were in the public record or of which all parties were aware, comma, shall so far as necessary be deemed to have been approved by the parties. We'd like to strike the language and bind each of the non-operators. Words matter in these contracts, and binding has a particular meaning when we talk about how contracts affect the parties. It's a legal term of art, in my opinion. And to be able to bind a party that's just coming into the unit to some agreement or some action between the operator and a third party, I believe that language is a little over the top and could possibly disincentivize someone to be a participating party. And now, if that's the intent of the changes by Saltworks, I can understand that, but I think adding that language that limits the actions to which a participating party would approve has to be limited to what we know about. And so if it's actions they've taken, we know about it, it's in the public, particularly like what the exhibits to the application for the development plan, all of those things, sure, we know that, but we just don't know everything. And so we would like to limit whatever actions were deemed approved to what we know about. So that's my comment on that particular section. And I won't have comments on all of the changes. Like I said, a lot of the changes that Saltworks made were great. And
Mr. Rankin, before you gravitate into other sections, maybe we could hear from the commission or Mr. Daly or Mr. York. Any disagreement with the suggestion by Mr. Rankin? Let's start with you, Mr. Daly.
Yes, absolutely, we disagree. This section of the operating agreement is designed to assure that those things which have occurred in the unit prior to the election of a party to participate will be things that the new participating party is obligated to pay for. It is imperative, if someone elects to participate, that someone does enough due diligence to know what's going on out there and assume the liability to pay the bills or their proportionate share of the bills. What I see with Mr. Rankin's proposed language is a bunch of litigation over whether or not somebody knew something. And for that reason, as an attorney, I find objection to it. There are representatives of Saltworks in your hearing chamber right now, Mr. Lovasso, and Mr. Parsons, and they may very well want to add to what I just said.
Director?
Unfortunately, I think the reality of the situation is that no one will ever know everything about one of these units before they have to make a decision to participate or not. And much of that information may well not be in the public domain. So I am comfortable with the language that we presented.
Mr. Rankin?
As a follow-up, I'll just say, as I mentioned, the other operators have all proposed joint operating agreements, and there are joint operating agreements in place at the Lanxess unit. None of those languages have this type of language in it. This is a wholesale change proposed by Saltworks. And if everyone else was comfortable with it not being in there, I don't know why it needs to be in there in this one too. So this is a change that Saltworks wants to protect Saltworks. And we would just.
May I answer that?
He's not done yet, Mr. Daly. Hold on. Go ahead, Mr. Rankin.
No, that's fine.
Okay.
I'll let Mr. Daly.
Go ahead, Mr. Daly.
Mr. Rankin makes entirely too much of the difference between the operating agreements. Let me explain. I am the author of both operating agreements. I'm a co-author of the Saltworks operating agreement. There are a lot of experts, operating agreement experts employed by ExxonMobil who contributed to that effort. But the agreement that was included in the TETRA application is identical or virtually identical word for word to one that I drafted in 1989 for the Great Lakes Chemical Corporation South Plant unit, and then was used in the Central unit and the West unit. What I did, somewhat clumsily, was take a 1982 AAPL model form operating agreement and attempt to go through it and make it brine as opposed to oil and gas centric. That's all in the world I did. There has never been a dispute about that operating agreement, but there are no participants in any of those units with the exception of the one Great Lakes unit, and there's never been a dispute over the operating agreement. And it actually came about under very different circumstances, because when those 3 units were formed, all of the wells were already in place and in production. And the units were in fact formed in order to avoid trespass liability, which came about as a result of litigation. It's not a bad agreement, but this one's better. This one's better because the experts, particularly at ExxonMobil, took the time to go through it line by line and modernize. And we believe certainly that a requirement that if someone comes in late, elects to participate, these people have been, invited to participate long ago. If they come in late and they elect to participate, they should be liable for those things which have occurred, for the cost of those things that have occurred, and are enumerated basically in the remainder of the operating agreement. There again, I don't think you can say this shouldn't be here because it wasn't in that old agreement. This is better than that old agreement.
All right, thank you, Mr. Daly. Commissioners, any questions for Director York, Mr. Rankin, or Mr. Daly on this matter?
Mr. Daly, the word bind in there, parties and bind each of the non-operators. Who does that word benefit in your opinion?
You change that word to be liable for or something. Yes, you could, but bind means it's taken and you can't complain about it. And if it's,
I know
you have to pay your share.
Who benefits from it?
Well, the participating parties, including the operator, who've already enabled those activities to take place. It avoids the possibility that you could participate late and get a free ride on things that have happened in the past.
So are you saying both sides benefit from it?
Well, I think when you participate, you get the benefit of the activities in the unit. And in trading that off, you should be bound to pay for it as to your proportionate share. And that's what bind means in that context.
I know what the word means, but it benefits either one side or the other. And that was the intent.
It benefits the parties who are already participants.
Not the operator.
Including the operator, certainly. The operator's got at least 75% or he wouldn't be the operator.
Okay. Thank
Any other commissioners? Mr. Perkins, you came, excuse me, you came up, sit up here. I assume it's because you would like to say something?
I would like to add something, of course, along with, Mr. Rankin, I represent Occidental in this matter. Here's the problem. No reasonable business person likes to agree to a liability that when they don't know what it is. Mr. Daly is exactly right. When the operator and participating parties have paid to develop the unit, new entrants should pay their fair share. Oxy is not disagreeing with that. What they're saying is, we want to know what that is. So if they're going to charge them for it, why can't they issue a schedule of charges to which a new entrant is going to be responsible in advance so they can make an informed decision about that? That's all they want.
Thank you, Mr. Perkins. Any further questions, Commissioner Weiser?
So mechanically, what's being proposed is different than integrating a party in an oil and gas unit, where you present them with an AFE, they get an itemized statement as to what the costs are, and they yay or nay.
It's very similar, but that's what we're saying is, if they're going to charge them for it, they must have some record of what those charges are. Why not just make that known and say, these are the liabilities you're agreeing to if you elect to participate?
That's objectionable by Saltworks. Mr. Daly.
I'm going to defer to Mr. Lawasso and Mr. Parsons. I think I've said all I came to say.
Well, okay. Kind of gravitating it through almost like, it's not really a cost.
Just to help my counsel out, and I certainly adhere to my counsel's guidance on a variety of these areas. I would just like to point out that.
So hold on a second. Here's the concern I've got. So far I've just heard from lawyers. I can't swear them in. I don't have a docket. I don't know how to swear you in for something. I don't even know if it's appropriate to hear from just lay witness testimony. I guess it's just like a public comment. Correct.
I think this is a comment.
Yeah,
consider it simple commentary.
Because this is the public forum, anybody from the public can participate.
All right. I just want to make certain that that's what we've got.
Yeah.
And I'm not.
Put this at this juncture of the hearing.
Yeah, I just want to make certain I wasn't on really, really thin ice. I'm sorry, so go ahead.
I would just like.
State your name, please, so everybody.
My name is Remy Lawazo. I'm the lithium area manager representing Saltworks. Thank you. The unit operating agreement, as well as unit applications, contain a list of say, prior wells and expenditures that are requested at that point in time. Saltworks would have as well as future and forward looking. So I believe through the application process, that kind of visibility to those, if we're specifically speaking about costs and other aspects, are provided through that unit application process that exists with this commission.
All right, thank you, sir.
And Mr. Daly can correct me and Mr. Wasso too, but I think during the Saltworks application, it said that the actual expenses and, what you're going to be charged with will be provided after an election is made. They were keeping all of that information, close to the vest as they were integrating and creating the unit. So at this point, this agreement will have been adopted by this commission before we have to make that election in September. So to bind us to those prior actions before we have that opportunity to know what we're buying into, we think is an overreach. And we don't think this type of language belongs in that.
Any other questions on this particular verbiage in the model agreement?
Mr. Rankin, that's the reason you want to take the word bind out, that part.
I want to take the whole phrase out at this point, but if we are going to leave it, I think it just needs to be limited to us approving prior actions that we know about. Right now, all we know is the development agreement and the attachments to the applications, their maps of where they're going to drill their wells. We have a general knowledge, and right now that sounds great. But if you're gonna say, and we're gonna bind you to everything else you've done at the time you're signing this agreement, when we don't know what that is, and we may not know that until we have to make an election. That's the concerns for the language.
Won't know until after you say.
Well, certainly we won't know until after we make an election to participate, and by then, this commission will have adopted this language.
Victor, is the intent of staff to have the commission adopt this language today via a motion?
Correct.
I assume that there's other. Mr. Rankin looks puzzled.
Well, I know that July 21st is the day that the commission is going to deem it approved. And that's in keeping with the timeline that the working group set out that the director.
Correct. If I didn't elaborate on that, my intention was to ask the commission to review and approve it today with an effective date of July 21st. Then that gives all the parties the full advantage of both the 90 days that the commission placed in the original unit application, as well as the 60-day election period. And in my discussions within that working group, there was no opposition to that concept, that all the parties subject to the integration would get the full benefit of that 90-day period in which we were to review and create a model agreement, as well as the 60-day election period post that adoption. So my intention was to hear it today, review it today, and if approved, it'd be effective on July the 21st.
There's other verbiage in this document that you have an issue with as well, Mr. Rankin?
There are a handful, most of the, actually, there's maybe 3 more that we just really, some burr under our saddle, as you would say, and we'd like to address those.
Sure.
I would certainly hope that the commission would take these comments today. If the commission wants to make a motion, then certainly the commission can do that, but take our comments, consider them, and then adopt a joint operating agreement within the timeline as everybody was expecting.
So that's the commission meeting in
Post that day.
that's what I thought. So how will they procedurally do that, Mr. Rankin?
I don't have a clear answer for that, but I guess what I should do is go through our comments, and then the commission can
I'm
take them or leave them.
My mind's kind of turning here in terms of what the appropriate process or procedure should be. But go ahead, Mr. Rankin.
Should we move on from that?
Please.
Okay,
Yeah.
so the next section of the agreement we'd like to talk about is Article 5F, liability.
What did you say?
It's 5F, BF, 5F. Page 18 of the draft. It's actually called limitations of operator liability. Oxy had made the comment during the working group that we didn't think that this whole section of limitation of operator liability was necessary. Again, commenting that it's not included in any of the other drafts proposed by any of the other operators and not in any of the operating agreements in place. Simply stated, it seeks to limit liability for gross negligence and willful misconduct, which I think is a great overreach, at least in the joint operating agreement. We may see that language in a master service agreement or some other type of contract, but in this one, it's never been included in a joint operating agreement. Oxy would disagree with Saltworks' position that it is common in the oil and gas joint operating agreement. It's not in any of the joint operating, or it's not common in any of the agreements that Oxy is familiar with. And if the commission were inclined to include that language, like if section F2 is particularly troublesome because it basically requires a participating party, a non-operator, to indemnify the operator for willful misconduct and gross negligence, which I think is also a huge overreach. And so if we're going to leave parts of this provision. We would like to see the indemnification for gross negligence and willful misconduct stricken from that particular section. And then just to wrap up on that limitation of liability, subsection 4 talks about the senior supervisory personnel, that the liability could be limited to, or there's gross negligence and willful misconduct of the senior personnel be something that would be limited. We just think limiting it to senior personnel is curious and something of an overreach, and just supplement that language with operator. It starts out senior supervisory personnel misconduct. Just make that operator misconduct and take out senior supervisory personnel. I know in some of our discussions, staff initially agreed with that. I don't really understand why they changed their mind on it, but we certainly think limiting it to senior supervisory personnel is unnecessary. Those are our big comments on that, but just know that we think that the whole limitation of operator liability section should be stricken, as it is not something that is common to joint operating agreements that we've seen so far.
All right, thank you, Mr. Rankin. Mr. Perkins, anything to add on that?
Nothing to add at this time. Thank you.
Mr. Daly?
I'd like to defer to Mr. Milazzo.
Bring him back. Those are just keep your seat. I'm sorry.
Yes, I mean, as we've said, our comments have been provided through the actual working group process. And we appreciate the commission staff and attention to that as it works through. Certainly from ExxonMobil's experience, this type of language is very common in joint operating agreements and others that we have around, because it sets forward a good practice that allows all the parties at the onset understand the metes and bounds of liability and to make informed decisions around participation. Additionally, the specific language and some of the references to senior supervisory personnel, and I'll ask that Director your comment, comes from recent AEIN forms as part of standard joint operating agreements. So this is not something that we've just come up with. It's part of a standard within industry.
Thank you, sir. Director?
Just briefly, unfortunately, where we continue to have no consensus or disagreement on some of these items, I was in the position, or I believed it to be my role, to kind of make the call on the language that was put in the draft before you. So that decision was mine, where we still have disagreements, and I've put that before you because I believe that it's a reasonable clause or reasonable language to move forward with.
Right. Any follow-up, Mr. Rankin?
No.
All right, anything else you need to add in terms of language?
Not on the limitation of liability section.
Okay. What's the next section then?
The next section is Article 6A, very first paragraph. There was additional language that I think the intent of it was great. The language is that material alteration of the proposed initial development shall, and I can't read with the shading very well.
So it requires commission review and approval.
Shall require commission review and approval. The only question I have is, what is material? How big of a change? Another well, a moving of a well? I think the intent behind that language was good. I believe it was actually suggested by Equinor, but I just asked the commission to consider that, whether it needs to be defined or set out, or parameters set for that.
Thank you, Mr. Rankin. Yeah, question.
What page was that on?
That was at the very top of page 20. Starts with materials, that shaded language there.
Mr. Taylor?
Material is used in numerous contexts in legal agreements. And ultimately, whether or not something is material is, if there's litigation, determined by the court that is the final court that reviews the matter. I don't know a better word. I don't know. It's sort of like one of the Supreme Court justices, whose name I've forgotten, defined pornography. You know, I can't precisely define it, but I know it when I see it. It means important, but if you substitute important for material, you haven't solved what Oxy is apparently concerned about. If there is a constructive suggestion as to a better term, we would certainly listen to it. But we've been in this process for over a month and I haven't heard it.
Thank you, Mr. Daly. Director?
I have nothing to add.
What's up? Anything?
The addition of that language was not part of Saltworks' original edition, so have no further comment, but agree that creating some expected approval or burden or requirement to reappear without clear definition of what that is does create a complication and an ambiguity. In general, as I said, from Saltworks originals, we did not propose this original language, and given the ambiguity, I would almost propose at this time to strike it.
So, commissioners, questions on this issue? Mr. Rankin?
The final comment on the final section that we felt strongly enough to come before you today on is on section it's 7C, the taking in production. I'm about taking in kind. It's on page 26 of the draft. The proposed language in the Tetra agreement, the language used in the other proposed agreements, and the language that we see in the Lanxess agreement that's in place right now. Saltworks had proposed language that you see on this draft, which basically says that it takes out a provision of other joint operating agreements that if a taken kind party wants to take delivery of its taken kind product, and this agreement says that it has to be after a point where the brine is commingled. We didn't have an objection to that. But there's language in other agreements that say that the gathering and transportation costs won't be charged to a taken kind party. And that language is used in the prior documents. Saltworks changed that language to basically say that they would be charged transportation and gathering costs. And that's particularly troublesome because if we are a participating party, we're paying our fair share on the front end to establish this equipment and this system. And if we agree to participate and pay our fair share, once we get to a point where we want to take delivery of our taken kind product, they're going to charge us on top of that, when there may not be any additional expenses associated with it. But the language that was previously in the other joint operating agreements said that if there are additional costs, then those would be charged. But the language proposed by Saltworks goes beyond that and just says, we will charge you if you take in kind. So we would like to see the prior language in the prior JOAs used in that.
Thank you, Mr. Rankin. Parkins? Mr. Daly?
Yeah, Mr. Rankin, I'm sorry.
It's less, I was
gonna make a quick comment, Tom, and then you
go ahead. Yeah.
Your follow-up. I think the opening portions of this section is a very important context and consideration, and it speaks to specifically if operator or an affiliate company separately owns pipeline or facilities through which brine or effluent attributable to the unit is being carried. So this is not referred to pipelines and equipment that are part of the unit and that are part of equipment that is being paid for by any participant. In other words, this refers to if additional non-unit equipment that has not yet been paid for is deemed to add benefit to helping create a mutually agreed delivery point, then in that case, there would be I believe the terms were a commercially reasonable fee for the additional gathering and transport of that.
Thank you. I don't know if you need to add anything to that one, Mr. Daly.
Well, I would just a little bit. The language in the original agreement partially was put there because it envisioned the possibility that there would be a take point somewhere out in the field, and that the non-operator would take brine before the brine has been commingled. And that concept has been removed from this operating agreement for very good reason, because none of us are smart enough to figure out a completely accurate and equitable way that you could balance if someone took from one well and not from others. So we're requiring that the take point be after the brine is commingled. Under the previous possibility, and no one has participated, so we don't even have the problem. But under the previous possibility, the intent of that was that a non-operator wouldn't have to pay for pipelines when the brine, when it's already taken its brine at the earlier take point. Well, that isn't going to happen here because the take point has to be after the brine is commingled. So we are simply saying that whatever pipe gets brine from the field into the take point, everybody pays for, because that's where everybody takes. And nobody gets a free ride on it. And if it is separately owned, it doesn't matter if it is used for that purpose.
Thank you, Mr. Davis. Director?
Nothing to add.
Mr. Rankin?
We appreciate staff's, oh, sorry, one moment, please.
Sure.
My client just wanted me to point out that, even with the potential ambiguity in the word material that we were talking about before, we do think that a material change should require coming back to the commission. However, and we would want to keep the language. Our point was, how do we know as a participating party what that means? Were there some parameters the commission would consider? But certainly we don't think striking that is going to help the situation. So I know Mr. Wasso is trying to fix it by taking it out, but we think that it needs to be. And with that, I just want to thank the commission for the opportunity to come in and make the comments on this. The working group worked well together. By and large, certainly Oxy's agreeable to most of the changes that Saltworks made, and we appreciate their efforts on that too. But when staff submitted the draft that didn't take into account some of our changes, we just felt that we should address that with the commission, and we appreciate the opportunity to do that.
All right, anybody have anything else? Commissioners, any questions?
Judge Moulton, I just have a question for Director York.
Yes, sir.
Director, so the way you and the staff looked at this, obviously it was thinking about all stakeholders from both sides, non-participants and participants and operators, et cetera. I assume you tried to make it fair to everybody. Is that correct?
That is correct.
And one thing I've learned over 40 years in business is that you put 10 attorneys in a room, you usually end up with 12 different opinions about things. And that's a little bit of a tongue-in-cheek comment, but everybody has different opinions about language and words and all that kind of thing. And so for me, I would tend to go with the staff's recommendations, balancing everything in the working group that came together with all the different comments that different people made. And we need to probably address this and move on. So I would just recommend that we consider, I think, let the staff be the final arbiter of these things and using common sense. I think all these comments have been good by Mr. Perkins and Rankin and everybody and Tom Daly. But I think the staff probably is the best arbiter looking at the benefit of everybody involved. That's my comments.
Thank you, Commissioner. Okay. Commissioner Thomas.
Director York, I hate to make any comment on this with all the people that have worked on this, but on page 18, limitations of operating liability. I do have an issue with that. Looking at it as if I were being asked to participate in this unit. And all of us that have been in oil and gas business have had to pay for growth negligence, whether we liked it or not. And but I've never run into willful. But an operator has a standard, and they must be held to that. I think the operators of these units would be impeccable operators. We don't know what the future holds. I do have a problem with that as it's written.
The term willful misconduct.
Yes, I don't know how we indemnify anyone in business from that. So today, if asked to vote on this draft, I could not vote affirmative because of that one portion.
But if that were stricken,
If it was changed to the way these smart people could live with it, I would be happy to vote for it and move forward. I don't know how to fix it, but I couldn't invest in it. Thank you.
Thank you, Commissioner. Any other questions from the Commissioner? Commissioners, do you need more time to digest this document? I'm not saying days or weeks, I'm saying, well, an hour or two or whatever. What's the prerogative of the commission? Mr. Chairman, what would you like to do here? You're pretty close to lunch. Do you want to break for lunch and then come back and take this up after lunch? Or do you want to try to dispense with it before lunch, because I'm sure the director can make ask for a motion to be made?
There's more people on that board than me, so we might need to visit about it.
Is staff willing to make that change to?
absolutely. If that were, say, to be part of someone's motion, that term willful misconduct be stricken, staff would have no issue with that.
I'm not trying to hold up today's progress, and I certainly don't want to cost us any time. I was just giving you my opinion as someone that if I was asked to invest in this deal, that would be a hang-up.
This was one of those circumstances where basically the language was there either in whole cloth or not at all. And
can the principals, is there a fix today or not, Remy?
I was just saying that this language comes very specifically from AIEN, so, we're trying to maintain consistency with the industry practice.
If I may, again, staff's position is if you make a motion that the agreement be adopted with that language stricken as a condition to your motion, I have no issue with that.
I just don't, if I'm unreasonable, I don't want to tie these parties up. I've been unreasonable. I was just giving my opinion as one of your commissioners. And so I don't want to be an encumbrance to progress, just giving my opinion. Like I said earlier, you don't have to have my vote today anyway, but it would have to be changed for me to vote in the affirmative.
Understood.
I just wonder if these parties here might, Remy said that it's common, so obviously he's good with it. So, Jim, you brought it up. What's the answer?
Well, we disagree that it's common in the joint operating agreement scenario like this, and certainly requiring a participating party to indemnify an operator for willful misconduct is a big overreach. So it might not go as far as we would hope it would go in striking this entire provision, but certainly would welcome that type of amendment to it.
Did y'all argue about this in the working group before it got?
I wouldn't say we argued about anything, but certainly Mr. Daly and I and others, I mean, we voiced our clients' positions and made our recommendations to staff.
Okay. I think I've made enough issue out of that, so thank you.
Mr. Chairman, what's the prerogative of the commission? What would you like to do?
If I may, Judge Moulton, just to remind the commission of a procedural point. When we were tasked with undertaking, trying to get to a model unit operating agreement, if no model unit operating agreement is adopted by the commission, then it would default to the unit operating agreement as proposed by the applicant originally. So there would not be any, if a model is not adopted by the commission, it would go back to the first version of this. For each applicant.
So you'd have different ones.
We would have different operating agreements. And we would also have operating agreements without some of the provisions that have been placed in here and the strike throughs that have been.
I think the commission's charge was to try to achieve some vestige of uniformity. So they're not going to jettison the whole concept. I just want to know, do they want to go for lunch? Not whether or not they want to reject the whole thing in its entirety.
Just as a closing statement, let's say, as we opened, and I think as some of the commission recognized, we really appreciate the work that staff has done to create that exact scenario, a model template that can be broadly applicable, that takes consideration, due diligence the staff and Director York here put into that. And that was part of our support and being an active and participant in that through a lot of back and forth in other areas. That certainly got us to this is different than the model UOA originally proposed by Saltworks. But we think the changes have been made that staff has considered with significant due diligence to create that balance and have seen good diligence throughout. So we appreciate that, and we do support still the draft as submitted by commission staff.
Mr. Director,
Sir,
what's the difference in gross negligent and willful misconduct?
I do not have my Black's Law Dictionary in front of me, so it would take me a moment to gather that, but that's something that legal staff, I think there is some, I don't know if it's total overlap, but I think there is some area that is covered by both. If you give me just a moment, I believe legal staff's pulling up the definition.
Somebody. Those misconduct. Is it? I know. Yeah.
Now.
It is defined in the draft on page 5. In addition, a legal definition is that the key distinction between gross misconduct involves knowing that there are risks, whereas willful misconduct means knowing there are risks, consequences, and outcomes and proceeding anyway. The definition as provided in the unit operating agreement has them as basically interchangeable. Gross negligence / willful misconduct means any act or failure to act by any person or entity that was intended to cause or was in reckless disregard or wanton indifference to harmful consequences such person or entity knew or should have known such act or failure would have on the safety or property of another person or entity. So in there, the definitions are interchangeable for those terms.
Well, the fact that it's defined is certainly helpful, and I think even our biggest objection was the carve out for senior supervisory personnel. Make it apply to the operator, company wide, and don't give a carve out to the senior personnel.
I may make a proposal that, if it's the commission's desire to break for lunch, let the, abbreviated work group see if we can make, some amendments to the draft and provide it to the commission after lunch.
Based on the comments from the commission.
Correct.
Thank you, Brad.
If you could do that, I would make a motion that would like be worked out, and I hate that I've called. Rocky. What I said earlier still stands. Thank you.
Mr. Chairman, ready for lunch, sir?
Yes, sir.
An hour?
Yes, sir.
All right, we will be back at, about 12:30.
Say 12:49.
Yeah, or I've got.
I'm trying to get you on. Trying to get.
We didn't take this back, right?
Take you that long to get my computer fired up, Jim.
Travel the road. Back to the office. Hey, Gary. Right, we need to place it back there, right?
Yeah.
One problem. Okay. I thought it was coming. I was thinking it just like.
We'll just give you a call about that, or maybe or something. Yeah, we'll just set up a time. You run it all. Or relax and have time to talk about it. Yeah, you never know.
Yeah.
All right, great. We'll take off. Yeah.
Good to meet you. Thank you. Thank you. Busy. Yeah. I didn't want to say thank you.
Hello.
Also.
Thank you, I appreciate that. Always fun to write about it, I thought I didn't realize when I first started writing about the well, there was as much as it was. I was going back through the
I can't hear anything. Are they, they're still, are they muted over there?
Yeah, they're still muted.
Okay.
Yeah, I knew that, you've done basically most of it. I was going to, I was like, I was out with them.
Told me that, I meant to ask you. Yeah. I haven't seen her in a long time, yeah, I'm working.
And it's just some company. Two million ourselves, so they can use that.
Yeah. Brian can.
Several those here.
It was important.
Was about lunch. All right, commissioners, you ready to proceed? If so, we are back on the record. My understanding that while we were at lunch, the director took some of his lunch time. And Mr. Rankin took some of his lunch time, and maybe some of the Saltworks people took some of their lunch time and visited, and you worked up some of the details in terms of this uniform agreement. So, Director, I'll turn it over to you, and you can explain to the commission what kind of accommodation and accord you have reached.
Thank you. To address Commissioner Thomas's concern, both Oxy, Saltworks, and staff came up with what we believe to be a reasonable compromise, and I believe we have consensus on this. On page 19, paragraph 4, I believe that's paragraph. Yeah, 4.
What page down?
Page 19. It's the one that's got lots of blue highlight on it.
Gotcha.
In that paragraph 4, the compromise is that the term senior supervisory personnel in the entirety of paragraph 4 would be stricken and replaced with the word operator. So that paragraph would now be styled as operator misconduct, and the terms there would all address the operator rather than senior supervisory personnel. We believe that read in conjunction with paragraphs 1 and 2 should wholly address Commissioner Thomas's concern.
Any other addendums, changes?
That was the only change.
Commissioners, with that change, Director, would you like the commission to vote on this submittal?
Yeah, my request would be, if the commission's desire is to approve this, to approve it effective on no later than July 21st. Therefore, allowing all those parties of those previous unit creation and integration orders would have the full 90 days plus 60 days to make their election. So effective on July 21st.
Commissioners, any questions either for the director, Mr. Rankin, Mr. Daly, the representatives of the president of the room? Questions from the commission?
Yes. Did y'all address the word willful misconduct?
We address it by those paragraphs refer to this paragraph, and basically it was saying but for senior supervisory personnel,
yes,
they wouldn't be held accountable or liable for willful misconduct. And by changing this to operator, it takes that exemption or exception away. That answer? Yes. Yes.
Mr. Logan?
No exception to the commission staff's recommendation.
All right, thank you.
And just for clarity, the proposed unit operating agreement would include the proposed model lease form as well, with the corrections made by staff. We need to go through that one in more depth if we can, but staff's changes to that by and large to address concerns that we had with that lease and some of the provisions in it being markedly different than the oil and gas lease that we use in oil and gas integrations. So we took out surface use provisions and changed the terminology to say brine interest rather than land, took out a right of first refusal to purchase, and a few other changes to protect those interests that are defaulted or deemed leased under commission order. Parties who choose to lease on their own, they can negotiate whatever lease that they so choose.
You did say it had an agreement in here on surface use.
It got rid of surface use. Because this is for the parties that are basically do nothing under the order and defaulted. So we didn't want to grant that provision.
Okay.
All right, any other commissioners' questions? Chairman, I don't know if you're ready for the commission make a motion on this, or if you need further discussion, but I'll turn it over to you, sir.
Me?
Yeah, sure, for a moment.
Anybody got any
public comment?
Anybody got any comment? Y'all ready to vote?
How are we gonna make a motion? Move with the changes suggested by Director Lord, seconded by Commissioner Thomas. All right, all in favor? Show of hands. Commissioner Lawson voted in favor as well, so that's 7 votes in favor. And that is for July 24th.
Right.
Thank you.
Thank you.
Director, do you want to stay out there? Director's report?
That was my plan, and I will be as quick as I possibly can.
Thank you, sir.
For the director's report for this month, just a reminder, our July hearing is scheduled for El Dorado. We intend to have both North Little Rock and Fort Smith offices available for any commissioners that want to operate out of those offices for that hearing. From a legal update, nothing has really changed in our crypto mining lawsuit that we were named in, but I will let y'all know late last week, Mr. Alan Perkins gave me a phone call to give me a heads up that he was preparing to sue us in our official capacities regarding Act 1024, which was the Representative Beck legislation regarding royalty changes or royalty payments. So we're named in our official capacities, not individually. So I accepted service of that lawsuit on Friday. I believe that the Attorney General's office has agreed to represent us on that. So I'll keep y'all up to date as that progresses. In July, I intend to give you a rundown of the commission's finances, a wrap up of fiscal year 25, and then kind of a preview of fiscal year 26. Got a text an email this morning. We had referred the Norphlet pipeline and the large tank that I believe we called the Big 80 to EPA. EPA has said that they don't have money to address it. So we are in discussions with DEQ on their end to see if there's any avenues that we need to check out beyond that. We will more than likely ask EPA to reconsider that because we do believe that part of that Superfund site that was the former refinery. Lastly, Chairman was gracious enough to take me on a ride out in the field a few weeks ago. Thought it was a good visit. It was a good time for me to go out and see operations in the field. One of the discussions we had was the Graves Formation and standing pressure on the Graves Formation. So I am asking the Office of State Geologist to start a beginning of what I'm calling a static pressure study, so that we can understand kind of what head pressures we have on the Graves Formation across the field, just so that we have an idea of where our areas of risk for potential future breakouts might be as a starting place. Just so you know, and Commissioner Bangle, I asked his input on this, and he seemed to think that if we work through it, we might be able to come up with what I believe he termed as kind of a risk map of wells that were plugged using the old, what I call the old methodology, the pre-World War II methodology, so that we can be better prepared if we have a breakout. So I will keep y'all up to date on that. If you have any comments or concerns, you feel free to reach out to me. But at this point, it's basically a science project so that we can understand and map the field.
Spot Osbrooks, we're probably the people that will be working on
Had a discussion with him before we came down.
All right.
He knows.
Director, is that the summary report?
That is it.
So, I know the royalty docket's kind of got us off our schedule a little bit. Are we gonna be in Fort Smith next month?
No, sir. It's scheduled for El Dorado.
Okay. I couldn't figure out where we were gonna be. I think we're supposed to be in Little Rock this month, right?
We were supposed to be in Fort Smith this month, if I recall correctly. I may be wrong, but yeah.
So next month is El Dorado.
Yep. But again, we will have the Little Rock and Fort Smith offices available for Zoom participation.
Thank you.
June meeting is adjourned.
Thank you. Appreciate it. Yes, sir.
Yeah.